this is not legal advice. This is just clearly, patently an unconstitutional policy. It's not a law, like these cops lie and say. They lie to your face and say it's a law. It is not a law. In fact, the law is you're allowed to record in a police precinct. The law is you are allowed to record. So they lie, bold-faced lie straight to your face.
Step outside, because then it's handcuffs afterwards, so step outside. Go ahead.
The sign is right here.
That sign is not a law, Sergeant.
Yes, it is.
No, it's
It is a
not.
law in the
It is
city
not
of
a
New York.
law.
They lie when they say it's a law. It's not a law.
So just so you know, you can't record inside police precincts, any police precinct, whether it's New York City, outside.
You're not allowing me to record inside, even though there's no law against recording inside the
Yes,
lobby.
sir. No, or outside.
It's not a law.
There's a reason why it's posted in that particular spot, okay?
It's an unconstitutional policy which violates the law. That's what it is. And I invite any NYPD to come on the channel and debate with me about it. Hello, everybody. How are you doing on this fine Monday, April 10th? Today is actually the court date for Bam Margera's restraining order. I do have a friend over there on the way to the courthouse right now. I will let y'all know if anything eventful does happen. I already know this is about to be a long video, so let's just get right into it. In my most recent video, I did show y'all what happened when Sean Reyes from Long Island Audit tried to record in yet another police precinct. The first time that it happened was at the 61st precinct. He did get arrested. They stole his property. They stole his freedom. They still haven't given him back the evidence of their brutality, and he is fighting to get that evidence back. Now, that case is going to court on April 23rd, which is a Sunday, weirdly. The most recent video I made on this matter actually dealt with what happened whenever Sean tried to record in the 105th precinct. He was there to actually file a complaint about the brutality and the unlawful activity that he experienced at the 61st precinct, and the 105th precinct was no better. So if y'all missed those two reaction and response videos that I made, I do have them in the playlist for Long Island Audit. But in my last video, I did show y'all another instance of brutality that did occur to another citizen, another one of We the People, whenever she tried to record in a police precinct. That time it happened in Brooklyn precinct number 62. So Sean went to 61. What happened to this lady happened in precinct 62. Now, there are full videos up on the internet about this encounter that I am probably not going to be able to show you in full on this channel, at risk of having the video be surprised, demonetized, etc. But I did show y'all briefly what happened when this lady, Patricia Rodney, a 61-year-old grandmother, she had gone to the precinct in order to ask for a complaint. She did not actually need the police to do anything. She wasn't asking them to investigate. What had happened, according to Patricia, was that her diabetes glucose meter had been stolen. So she needed a complaint showing that she had reported the theft to the police. The reason she needed this complaint was that she was filing for another glucose meter on her insurance, and her insurance policy, her insurance company, was requiring that she did report it to the police. So all she was trying to do was get the police to make a copy. That's all she was trying to do. She wasn't asking them to investigate. She wasn't asking them to come up with a list of suspects. She just literally needed a piece of paper for her insurance claim. Well, instead of leaving with a piece of paper, she left in handcuffs with a broken arm.
That's not a body camera. No. This is my camera. I'm allowed to do it.
You see right there? You see that behind you? You can't record.
You can't record in the...
You can't record.
I can
Man,
record
we're asking you to
outside.
leave. You're not leaving, and you're not allowed to record.
You're not allowed to...
Turn around.
Excuse me.
Turn around.
Calm down, roll over. Stop resisting.
They broke this woman's arm, and it didn't end there. The confrontation happened during the time where masks were mandated. And she did, according to the mandate, have a mask on. But as they were walking Patricia After completely terrorizing and brutalizing her, they were walking her out of the precinct in handcuffs with a broken elbow. They were bringing her to the hospital because they broke her damn arm. As if that's not bad enough, one of the tyrants took her mask that she was wearing over her mouth and moved it and put it over her eyes.
I was here 2 days ago.
Put up your mask.
Put away my mask.
To cover up her eyes. Why did they do that? Nothing more than terrorism and brutality, if you ask me. So, as I have previously reported, there is a law that protects citizens' right to record the police in precincts. There is a New York state law that was passed by the legislature in New York. There is also a New York City ordinance, aka law, that was passed by the New York City Council. And of course, there's the First Amendment, which obviously allows us to record police in the process of performing their duties. So after y'all saw the NYPD put that mask over Patricia's eyes, and after they completely brutalized her, a lot of y'all are asking me in the comments, what happened with that case? What happened to Patricia? Did anyone face any accountability? What is going on with that case? So, by popular demand, I'm going to let y'all know what I've been able to find over the last day or so having to do with that case. Now, Patricia did sue I believe the city as well as NYPD. There's an ongoing lawsuit. So I do want to show y'all what I have found so far having to do with that lawsuit. I also, in connection with all of that, will show you something that has been written in the case by the New York City public advocate, Jumaane Williams, I think is his name. And he actually talks about some of the reasons behind his drafting of the right to record police city ordinance. So without further ado, let's get into it. As usual, we are going to start at PACER. This filing was in the Federal District Court in New York's Southern District. It was filed about a year ago, last year in February. Patricia Rodney is the plaintiff in the case. That is the name of the victim. And the case number is 1:2022 CV01445. When you click on it and you go to the docket report, which is what I usually do, I'll go run report and you can see the information about the case. Usually what I like to do is go to the most recent filing. The most recent filing did happen on this month, April 5th, so 5 days ago. There was an order terminating a letter motion for a conference. It says the court will address this issue at the May 18th status conference. This order does not in any way act as a stay on other discovery. The clerk of court is respectfully directed to close number 79. Okay. So the case is still ongoing. We see the first non-deficient complaint filed on February 23rd, 2022. Right here. See, complaint against City of New York, Tamara Clemente, Hernandez, John and Jane Does, 1 through 10. Document filed by Patricia Rodney. So first thing I want to do is briefly go through that complaint. I want to go through the complaint and we will see what Patricia and her lawyers are saying happened to her. Once we look through that complaint, I also want to look at one other document that was filed in this case, and that document was filed by the person who actually drafted and presented this right to record police city ordinance. So first, let's go to the complaint, which again was filed about a year ago on February 23rd, 2022. It is a complaint and she demands a trial by jury. When plaintiff Patricia Rodney lost her glucometer, her insurance company told her she needed to provide a police report in order to have it replaced. The interaction that the insurance company demanded between citizens and the police should be simple, straightforward, and unfraught. But with the NYPD, no interaction is. Instead of getting a simple piece of paper, Patricia was brutalized, repeatedly lied to, and hospitalized.
I just hit a paper. I was here 2 days ago.
Put up your mask.
Put away my mask.
NYPD's excuse for the brutalization is even a bit ironic. The fact that plaintiff was brutalized because she dared to peacefully and unobtrusively record the police's actions demonstrates the dire need to reaffirm citizens' right to record. It is not hard to imagine that if Patricia had not been lucky enough to have what happened to her captured by countless body cameras,
Put up your mask.
the NYPD would deny the worst of the abuses she faced,
I'm telling you, turn around!
including having an officer callously and casually pull her mask over her eyes for no reason at all. But all of it is on film. And the city council has long since made the legal decision that citizens must be allowed to record all the public activities of the NYPD. So, as set out below, Patricia, who's the plaintiff, should recover for her brutalization. And the court should enjoin future enforcement of the NYPD's policy on station house recording ban as both unconstitutional on its face and unauthorized under city law. So the attorney in this case is arguing we need this court to reaffirm the public's right to record the police during their duties in public. And not only do we want this court to say that it violates that city ordinance for this little silly policy that says you can't record in a precinct, but also that it is unconstitutional. And I imagine that is why they did file this in the district, the federal level court, because it does deal with an issue of constitutionality. Now, if you're asking me my opinion, this is not legal advice. I believe that it is absolutely within the confines of the First Amendment that we are allowed to record police in the course of their duties, period. Anybody, anytime, anywhere. But now we have a state law that allows police to be recorded, and we have a city ordinance presented by public advocate William. And the city council voted almost unanimously in favor of this. I think maybe one or two people voted no on this. It was very comfortably passed. And there is video recording of this ordinance being passed, and I have been watching it. I'm about 2 hours into the recording now. I will update y'all with what I find from that recording, but now I just wanted to discuss the complaint and this amicus brief that was filed by the public advocate. All right, so now they are talking about the parties, the venue, and the jurisdiction. I'm not going to get too much into this, but this is where they basically say, these are the parties. This is why they fall under the jurisdiction of this court. Police Sergeant Hernandez is one of them. He was assigned to the 62nd precinct. He is sued in his official and individual capacities. We have Officer Tamara Clemente, also assigned to the 62nd precinct. The defendants, John and Jane Does 1 through 9. So here are the relevant facts according to the complaint. On December 2nd, 2020, about 5:50 p.m., plaintiff was lawfully present inside of the station house of the 62nd NYPD precinct to obtain a police report. A few days prior, on November 30th, she went to the station house to file a police report for her missing glucometer. She does have diabetes, and she was instructed by her insurance company that in order for her to obtain a new glucometer, she was first required to file a police report for the missing one. Her insurance company instructed her that they required her to fax to them an actual copy of the police report. Plaintiff is required to check her blood sugar about 5 times a day, and she works in a high-risk environment for COVID. She also has a history of high blood sugar, and she has been hospitalized for it in the recent past. Complying with the insurance company's directives to obtain her life-saving treatment, on November 30th, 2020, she spoke to a police officer inside of the 62nd precinct, and she was doing that in an attempt to get her police report. Plaintiff, that's Patricia, filled out the police report as required and then asked the police officer for a copy of the report so she could fax it to the insurance company and obtain her glucometer. The police officer responded to her request, telling her in sum and substance, I can't give you a copy of this paper you filled out. I have to make an official report. You can come back Wednesday to get this report. That Wednesday was December 2nd, 2020. Okay, so the glucometer is misplaced. She can't find it. She calls the insurance company to get a replacement. They say, we can't replace it for you until or unless you get a police report. She says, all right, no problem. Goes up to the police station, says, hey, I want to file that my glucometer is missing. This young officer has her fill out a report. She fills out the report and she says, hey, just make me a copy. The police is like, oh no, I can't make you a copy. I have to file an official complaint. So you can come back on December 2nd and pick up your copy. So December 2nd rolls around and she comes back to the precinct. Defendant, NYPD police officer Jane Doe 1, spoke to the plaintiff inside the station house, but she refused to give Patricia a copy of the police report, despite the fact that when Patricia filed the police report, another officer specifically told her to return to that station house to obtain a copy. This police officer appeared to be a Black woman with braided hair and was wearing a blue NYPD uniform. So we don't know their names, so they're just describing them. Defendant, NYPD Sergeant Hernandez, spoke to plaintiff inside the station house, but also refused to give her a copy of the police report. It's really not that hard, y'all. Make a copy and give it to the person. Defendant Police Officer Jane Doe 2 also spoke to Patricia inside of the station house and also refused to give her a copy of the police report. Plaintiff does not currently know her name, but she appeared to be a woman with long brown hair. Much of the NYPD's brutal assault of plaintiff was captured on body-worn cameras, and one video can be viewed here. So they put a link to the video. As can be seen in the video, Patricia, the plaintiff, is in the atrium of the station, separated by a sealed door from even the public part of the interior. Defendants, that's the NYPD, informed Patricia that they are recording her, and in turn, she informs them that she is recording on her phone. And we have a footnote too. She was not actually even recording them. She told them that because she was afraid that without them knowing they were being recorded, that they would abuse her. But the NYPD perceived that she was recording, and every action they took was based upon that perception. So come to find out, Patricia wasn't even recording. She was just saying, oh, I'm recording you, in hopes that they would not.
No, this is my camera. I'm
I'm
allowed to do it.
You see right there? You see that behind you? You can't record.
You can't record in the.
You can't record.
I can
Man,
record
we're asking you to
outside.
leave. You're not leaving, and you're not allowed to record.
Repeatedly brutalize her and put her in the hospital, but they did that anyway. Defendants, that's the police, became agitated and enraged on hearing that they were being recorded. They immediately escalated without even allowing a response, from demanding plaintiffs stop recording to assaulting her.
And you're not allowed to record. Turn around.
Excuse me.
Turn around.
Hey!
At that point, the NYPD, Jane and John Doe's 3 through 9, we have 6 people without any warning, justification, or legal excuse, handcuffed Patricia's wrists and shackled her ankles, pushed her to the ground, and began twisting her arms, causing her to cry out in pain, which we did see the video of that, and it is available publicly. Despite plaintiff's cries and total lack of resistance, the cops continued to use extreme force against her. As stated below, their actions caused an avulsion or a fracture of Patricia's elbow. They continued to make angry expressions like, I'm not playing with you. And that's it, you're going to jail.
That's it. Now you're going to jail.
As they manipulated Patricia's arm, despite already having fractured it. As a result of the defendant's excessive force against Patricia, she sustained pain and swelling to both elbows, arms, and wrists, including but not limited to a fracture of her left elbow. As is visible in other body camera footage, defendant's actions caused Patricia's face mask to fall below her nose. So you see her face mask did get knocked down. One of the defendants then punitively adjusted her face mask to cover her entire face before he just calmly walked away. Look, and that's him right there, putting the mask over her whole entire face, her eyes and everything. Look at that. That's what he did. He thought that was cute. He thought that was funny. He thought that was acceptable. He thought he would get away with it. But he will not. We, the people, will not stand for this. We will not stand for it. Throughout the entire encounter, a large number of the cops were not wearing any masks at all, creating an undue risk of infection. I don't know about this undue risk because I don't really think those cloth masks were shown to really do much, but I'm not a doctor, so, all that. Defendants then took Patricia to a local area hospital to receive treatment, for the injuries she sustained when they assaulted her. Patricia remained detained and handcuffed while at the hospital. The cops then took her back to the 62nd precinct where they detained her for several additional hours before she was taken to the Kings County Central booking. Plaintiff was detained at Kings County Central booking for several additional hours pursuant to false allegations made by the cops. Police Officer Clement swore out a criminal complaint against Patricia, which contained false allegations and which that officer knew for a fact were false when she made them. In support of her false criminal complaint, defendant Clemente made several material omissions, so she left stuff out, and she made false statements, including but not limited to alleging that Patricia resisted lawful arrest by extending and locking her arms and refusing to turn onto her stomach while Clemente attempted to place plaintiff in handcuffs. And a lot of y'all have told me that you either were law enforcement officers, you dated one, you knew one, your dad was one, and y'all have told me that police officers are actually trained to holler out, "Stop resisting, turn over. I told you to turn over," in order to be able to make claims like this, in order to lie and say that we the people were resisting, we were not complying. The police officers are actually trained to scream out, "Stop resisting," even when you're not resisting.
Stop resisting. Stop resisting.
In order for them to make false claims against you. This is part of their training. This isn't some rogue bad apple theory. It's how they're trained. These and other allegations were false, and defendant cop Clemente knew them to be false when she made them. Defendant Clemente forwarded these false allegations or caused the allegations to be forwarded to the Kings County District Attorney's Office, despite the false nature of the allegations. At her arraignment, Patricia acceded to an adjournment in contemplation of dismissal, and her charges were eventually dismissed. So all these charges were dismissed. She wasn't actually charged criminally in the end. They were dismissed. At no time did the cops have probable cause to seize, detain, or arrest Patricia, nor to use any force on her, nor was it reasonable for the cops to believe that such cause existed. At no time did any of the defendants or any other member of the NYPD take any steps to intervene, prevent, or otherwise limit the conduct engaged in by their fellow officers. So all those good apples, all those not bad apples, none of them stepped forward and said, "Hey, maybe y'all should stop brutalizing this woman and breaking her arm." No one stood up. No one, not one person. The cops were acting within the scope of their employment, and their acts were done in furtherance of the city of New York's interests and without legal justification or excuse. So now the complaint gets into the unconstitutional and illegal no recording policy. In 2018, the NYPD developed a new policy forbidding civilians from recording inside precincts. And they have a footnote, and they link to a New York Post article that we did read together in the 61st Precinct reaction video. That policy was released in apparent response and retaliation for an individual who swore at police officers in a police station. He recorded the incident, and he ended up in an argument about recording, during which he said, "I can record. I can do what the beep I want." And he left without being arrested. So basically, the cops didn't like that somebody had cussed at him. And so they went ahead and made an illegal, unconstitutional policy that says you can't record inside the precincts, basically because of their egos. I mean, we all know this. They're the ego police in the open air prison. The policy was crafted to provide police a way to arrest citizens recording at stations and to avoid bad publicity from such recordings, not because of a genuine concern for safety. Agreed. That's definitely what happened. The policy was created by the city in conjunction with Defendant John or Jane Doe 10. Defendant John or Jane Doe 10 had full decision-making authority delegated by the city to implement this policy. That defendant exercised that authority to create the policy. The lawyer says the policy is unconstitutional. It fails spectacularly to comply with even the bare constitutional minimums for government action that restricts the First Amendment rights. It doesn't make any distinction on the terms of time, place, and manner, which is required when you're going to infringe upon a citizen's rights, such as the right to record the police. The policy does not distinguish in terms of place. By terms, it is applied and forbids recording in the wholly public atrium, where there is no sensitive information, in the same way it forbids recording aimed at sensitive information. So basically, the lawyer is saying they made no attempt to limit the application of this policy. They were supposed to make exceptions on the time and the place and the manner. So if they wanted to say, for example, you can't record in the booking room in the back because, you might be recording someone's sensitive information. No, this unconstitutional, unlawful policy says that you cannot record anywhere as soon as you cross the threshold of a police precinct. And this is exactly the same issue that Sean Reyes has now dealt with twice. And I think there's another auditor named Brooklyn Audits or something like that who's also dealt with this issue within the past week. So it's very obvious to me, as someone who's passed the New York bar exam on the first try, unlike any of these police that we're talking about, this is not legal advice, that this is just clearly, patently an unconstitutional policy. It's not a law, like these cops lie and say. They lie to your face and say it's a law. It is not a law. In fact, the law is you're allowed to record in a police precinct. The law is you are allowed to record. So they lie, bold-faced lie straight to your face.
Step outside, because then it's handcuffs afterwards. So step outside. Go ahead.
That sign is not a law, Sergeant.
Yes, it is.
No,
It
it's
is a
not.
law in the
It is
city of
not a
New York.
law.
They lie when they say it's a law. It's not a law.
So just so you know, you can't record inside police precincts, any police precinct, whether it's New York City, outside.
You're not allowing me to record inside, even though there's no law against recording inside the
Yes,
lobby.
there is. No, so just so you know, it's stated right on the wall.
That's not a law. That's a sign.
So in regards, you're not allowed to record in any police precinct, whether it's New York City, in any one of the 5 boroughs, or outside.
It's not a law.
Okay, it's posted. There's a reason why it's posted in that particular spot. Okay.
It's an unconstitutional policy which violates the law. That's what it is. And I invite any NYPD to come on the channel and debate with me about it if they think they have the constitutional chops to do so. Similarly, this law fails to distinguish place, in that it applies to recording in places that the public has total access to, and they don't give any justification. So they're supposed to be having a substantial state interest whenever they have a policy like this, which would protect privacy, which this is not how laws are supposed to be made anyway. Laws are supposed to go through the legislature. Police putting a sign up is not a law. Police putting out a memo is not a law. Sorry to tell you, it just ain't. The policy also doesn't distinguish in terms of time. The policy doesn't distinguish in terms of manner. It applies to totally unobtrusive recordings. All of the recording that the policy restricts is recording of things that can be freely seen by members of the public. Any sensitive information that the policy addresses is already well protected by other policies, laws, and regulations. For example, if a person attempted to sneak a camera behind the desk at a station, the physical act of crossing the desk into the protected area would be an independent source of probable cause. Thus, all the policy does is serve to restrict legitimate attempts to document and record the public duties of the police. Defendants' own policies, so NYPD's own policies and procedures, state that there is a clear First Amendment right to record the police during the execution of their public duties. All of the defendants were trained on that clear First Amendment right at the academy and via in-service training. But in the field and at the station house, defendants were taught that the station house no recording policy overrides the First Amendment right, which is not true. It cannot do so. In other words, NYPD cops were taught that the NYPD is permitted to place limits on the First Amendment and state law. They're teaching the cops, you don't actually even have to follow the First Amendment because we can just put a policy in place that overrides that. That is the police state. That is where we live. That is the open air prison. And look, they still let this lawsuit go on. They haven't settled it. They haven't taken this policy off the books. Guess what? Just as recently as last week, somebody had this policy used against them. They're still doing it. They are violating the First Amendment of the United States Constitution, which they have promised to uphold. Plaintiff continues on the same insurance, and she needs to visit the police station for similar reasons. She doesn't feel safe around police at all anymore. She has the need to record future police interactions given what happened to her. She intends to record her future interactions. She intends to make trips to the police station, But for the violence she suffered for previously doing so, she would want to record. She will suffer irreparable harm if she is not able to record future interactions. Without an injunction, plaintiff will be too afraid of violent retaliation to record in police stations in the future. The first cause of action is false arrest claim against the individual defendants. She realleges all of the proceeding. They intentionally, willfully seized, searched, and detained and arrested her. She had not been engaged in any criminal conduct, and she was not engaged in any conduct that could reasonably be viewed as criminal. Despite the absence of sufficient legal cause, she was arrested, and they subjected her to a false arrest. The second cause of action is the denial of a fair trial. They willfully and intentionally fabricated evidence by falsely memorializing claims to have witnessed plaintiff engaging in criminal or unlawful activity. By lying on these police reports
Stop resisting. Stop resisting.
and fabricating false claims, they subjected plaintiff to denial of a fair trial, and they violated her right to due process by fabricating the evidence. The third cause of action is excessive force, because they obviously broke her arm for no reason at all. And the fourth cause of action is a First Amendment retaliation against all defendants. The NYPD retaliated against her for engaging in speech and other conduct protected by the First Amendment. They engaged in acts and omissions that are complained of in retaliation for her protected speech or conduct. Yeah, basically they violated the First Amendment, which we have already talked about. They go into the specific prongs of the legal analysis, which I'm trying to get to that other document. We're already at 35 minutes recording, so I'm kind of trying to rush through it a little bit. Then they get into the First Amendment retaliation by violence. She was engaged in the exercise of a First Amendment right, so it's kind of like a First Amendment audit when she stated that she was recording the cops. Clearly, it is established that citizens have the right to record police while they are engaged in their official duties. Plaintiff said she was engaging in that right. In retaliation for her exercising her First Amendment right, and with the purpose of chilling the right to record, defendants, the NYPD, brutally assaulted her.
You're not leaving, and you're not allowed to record. Turn around.
Excuse me.
Turn around.
Hey!
By reason thereof, they violated 42 USC 1983 and caused her to suffer emotional and physical injuries, mental anguish, incarceration, deprivation of liberty, and the loss of her constitutional rights. Then the lawyer talks about the unconstitutional policy. The municipal defendants created the policies categorically forbidding recording in police stations. Those policies violate the First Amendment in that they were viewpoint discriminatory, they were content neutral, but they lacked the narrow tailoring to serve a significant or substantial government interest, and they burdened substantially more protected speech than necessary to serve their interests. Because what they say is, oh, it's for our safety, but there's really no, it's not. It's for y'all's ego, and we all know it. That policy also violates the Constitution because it affords the NYPD unbridled or otherwise inappropriately limited discretion to limit or deny plaintiff's ability to engage in the First Amendment protected activity. It amounted to the imposition of strict liability on plaintiff for engaging in a First Amendment activity. As a result of the NYPD's actions and omissions, they deprived her of her federal, state, and other legal rights. They caused her bodily injury, pain, suffering, psychological and emotional injury, humiliation, and caused her to expend costs and expenses and otherwise damaged her. The fifth cause of action is the violation of New York Civil Rights Law 79P. Prior to her assault, battery, and arrest, she was exercising her rights under New York Civil Rights Law 79P, the New Yorkers' Right to Monitor Act, to record law enforcement activity. In creating the policies alleged above, the defendants, that's the NYPD, exceeded their authority because the rule created was inconsistent with the New York Civil Rights Law. So if y'all remember, we always do this hierarchy, right? The number one law at the top is the Constitution. Nothing can conflict with that. I mean, they do make laws that conflict with that, but they're not supposed to, and they're not supposed to be enforceable. So that's the supreme law of the land. The Supremacy Clause actually makes it so, and everyone agrees. The supreme law of the land is the United States Constitution. Under that, we have federal laws, federal statutes, which are put in place by the federal government. So a state cannot make a law which would violate federal act, a federal act like the Americans with Disabilities Act, for example. Then after that, in the hierarchy, you do have state level laws. And then under that, you have city ordinances. And then under all of that, you have police policies. Okay. So police policies are not law, and they absolutely cannot conflict with an existing law. So they can't even do a little police policy that conflicts with a city ordinance because it's below the city ordinance on the hierarchy, much less going all the way up to the top and violating against the United States Constitution, which is what this policy does. I mean, we've established that at this point. But this portion of the complaint is talking about New York Civil Rights Law 79P, which is the state law, New Yorkers' right to monitor. To monitor what? To record law enforcement activity. In creating their policies, the police exceeded their authority because the rule created was inconsistent with the law of New York, that's 79P. They violated Civil Rights Law 79P in that plaintiff exercised or attempted to exercise the right established in subdivision 2 of this section to record a law enforcement activity, and an officer acted to interfere with that person's recording of a law enforcement activity in one of the specified ways. NYPD created these policies that you can't record in the precinct intentionally to prevent New Yorkers from recording law enforcement activity, and that is illegal. They enforced those policies against plaintiff and other New Yorkers to deter them from exercising their right to record law enforcement activity. The Civil Rights Law 79P created a private right of action that explicitly provided for punitive damages and injunctive relief. A private right of action being provided in a statute is basically, it gives citizens a private right to sue, so you don't have to wait for the state to make a move like, oh, it's a crime and hopefully the district attorney is gonna no. You can sue yourself. You can sue under this law if they break it. And the policy in and of itself breaks the law, but especially whenever you break someone's bones, they are acting in accordance with that law, a civil rights law, no less, then you really extra double violated that law and you definitely getting sued, and get sued they did because we're reading this complaint right now. Now, the sixth cause of action is a 1983 Monell claim against the municipal defendant. So that's like the city of New York. The city of New York is responsible for ensuring that reasonable and appropriate levels of supervision were in place within and over the NYPD. The city of New York had actual or constructive knowledge that there was inadequate supervision over or within the NYPD with respect to its members' abuse of their authority, their abuse of arrest powers, excessive force, fabrication of evidence, and other blatant violations under the United States Constitution and the rules and the regulations. So basically this is saying, look, the city of New York had authority to put supervision over these people. They didn't do that, and look what happened. Despite ample notice of inadequate supervision, the city of New York took absolutely no steps to ensure that reasonable and appropriate levels of supervision were put into place, including specifically this plaintiff who now has broken arms that she's going to have to deal with for the rest of her life. The city of New York deliberately and intentionally chose not to take action to correct the chronic, systemic, and institutional misuse and abuse of police authority by its NYPD employees. They thereby deliberately and intentionally adopted, condoned, and created through deliberate inaction and negligent supervision an NYPD policy, practice, and custom of utilizing illegal and impermissible searches, arrests, and detentions, excessive force, manufacturing of evidence, and the ordinary course of NYPD business. This flagrantly disregards the state and federal constitutions, as well as the patrol guide up to and beyond plaintiff's arrest. The acts complained of herein are a direct and proximate result of the failure of the city of New York to properly select, train, supervise, and investigate and discipline police and correction officers. Okay, so seventh cause of action is more civil rights violations, false arrest, excessive force, denial of due process and fair trial through the NYPD's use of unreasonable force, fabricated evidence, and the making of false statements, aka lies. At no time did they have any legal basis to arrest her, subjected her to prosecution, commencing criminal process against her. There was no reasonable basis to believe that her conduct was unlawful. And there's also no reasonable basis to believe that the police's conduct was lawful, reasonable, or otherwise appropriate. They are liable under New York law to the plaintiff for false arrest, excessive force, denial of due process, and denial of a fair trial. Okay, so that is all for that. Oh God, I really one day I will have short videos. but it ain't gonna be today. So now I want to show y'all this. It's called an amicus brief in opposition to the defendant's motion to dismiss. So let me just so the NYPD hilariously filed a motion to dismiss. If y'all want me to read the motion to dismiss, I would do it on this video, but I'm already 46 minutes into recording. Like, these videos are just way too long. If y'all want me to read the motion to dismiss, leave a comment below and I will. But hilariously, the police filed a motion to dismiss. So in response to their motion to dismiss the lawsuit, the person who actually wrote the city ordinance, who would be the New York City public advocate, Jamani Williams, who was formerly a city council member, but now he is in a different position where he actually wrote, and I'm sure with a team, right? But he wrote and presented this law that reaffirms citizens' right to record in public.
My bill of the right to record, we have been obviously trying to push forward for some time to reaffirm people's right to record the police. Obviously, if they're not interfering with police activity. It does do some things that the recent state bill does not do.
We can also do a screening of the city council meeting where the city council voted on this law. But this is the city ordinance, which reaffirms citizens' rights to record police in public. It's very well established that a police precinct in the public areas of the lobby is public. Okay, it's not even worth getting an argument about. It's established. Okay, so that former city council member, who is now the public advocate, Jamani Williams, in November, so about 5 months ago, he himself put forth a filing in this exact court case. And it's 36 pages long. If I would read the whole thing, this video would be an hour and a half, plus my throat's getting a little sore. So I want to jump to the relevant part, which happens to be on page 8. And it says the Right to Record Act was passed to prevent the NYPD from interfering with recording by civilians, including in police precincts. All right, so then let's go to page 8, talking about the history of unlawfully interfering with recording. So we're on page 8. The Right to Record Act was passed to prevent the NYPD from interfering with recording by civilians, including police precincts. The sponsors of the city's Right to Record Act and the council members who passed it were well aware of the history of the NYPD in their interfering in recording. They passed the Right to Record Act to end the NYPD practice of allowing its officers to deny civilians the right to record them. By its plain language and the clear intent of the drafters, the Right to Record Act was meant to protect this right as broadly as possible, including in the publicly accessible areas of police precincts. But if any confirmation is needed that it was intended to apply to the precincts, the legislative history and the attached declaration of the primary sponsor of the bill provide it. So now they're getting into the principles of legislative interpretation, and they're talking about how to actually interpret this Right to Record Act. They go through the canons of construction. That was one of my favorite classes in law school, was like legislative interpretation. I did so good in that class. I think I made the highest grade in the class. A statute or ordinance must be construed as a whole. Its various sections have to be considered together. So the plain language of the Right to Record Act applies in precincts. So you have the guy who primary sponsor of the bill, one of its drafters, saying, look, this is what we meant. We definitely meant precincts. All these idiots at the NYPD acting like somehow, some way the precinct is not public. They're wrong. And I'm about to tell you why. The Right to Record Act states a person may record police activities and maintain custody and control of any recording and of any property or instruments used in that recording. It does not include any language limiting the right to record based on the location of the officer or the person recording. This broad, straightforward provision means what it says. People can record the police. Look at that. One more time. This broad, straightforward provision means what it says. People can record the police. Reading into the law an exception that is not in the text, except inside police precincts, would extend a statute beyond its express terms or the reasonable implications. The Right to Record Act contains a number of other exceptions, which demonstrates that the legislature could have added one for police precincts if it wanted to or intended to. For example, the Right to Record Act shall not be construed to permit a person to engage in activities that physically interfere with an official and lawful police function. function. There's also another exception that the Right to Record Act cannot be construed to permit a person to prevent the seizure of any property or instruments used in a recording of police activities where the seizure is authorized by law. And there's another exception that it can't be construed to allow someone to prohibit an officer from enforcing any provisions of the law. The city council included all the exceptions it intended to, and the canon of expression unius cautions us against engrafting an additional exception to what is an already complex statutory scheme. The Right to Record Act sets forth a generally applicable provision. It does not include an exception for police precincts, even though it does include exceptions for other stuff. The plain text of the act permits recording of law enforcement officers engaged in law enforcement activities, even when the recording is taking place inside of the damn precinct. Okay, so the first thing he gets into is how do we construe from a linguistic perspective? How do we construe this act? How do we get inside the minds of the people who wrote the act, who voted on the act, who decided to pass the act? How do we get inside their minds from a linguistic perspective? Let's look at the language of the statute. Let's think about what the most obvious thing they probably meant was, and he gave that analysis. The next part of his analysis hinges upon the legislative history of the Right to Record Act. It says the legislative history of the City Right to Record Act shows that it applies in precincts. When the text is clear, as the text to the Right to Record Act is, the court doesn't have to consider all this legislative history. But since the history only confirms what we're already saying, we'll go ahead and include that too. And it says the Right to Record Act was intended to supersede the NYPD's unlawful, unconstitutional policy of prohibiting recording in the precincts, and therefore it should be reviewed as the best evidence of the legislator's intent. The legislative history of the Right to Record Act shows that the council understood that the right to record police officers acting in their official capacity was already firmly established in New York City. It also knew that the NYPD administration refused to prevent its officers from interfering with that constitutional right. So the language surrounding the introduction and passage of the legislation emphasizes the people who wrote the Right to Record Act intended to ensure that the NYPD could not stand by while its officers interfered with civilians' rights. When the NYPD had first introduced the no recording policy, Chair Richards had specifically announced that the Right to Record Act would address the ban, which he said created a double standard in police stations. And this is saying that the chair Richards, the chair of the city council or the chair of the committee on this law or something like that, it says that this person actually specifically announced that the Right to Record Act was supposed to address the unlawful, unconstitutional policy that doesn't allow recording in police precincts. The authors of this bill, the chair of the committee for this bill, actually specifically addressed the no recording policy. When public advocate Jimani Williams, who had first sponsored the bill as a council member, introduced it in June 2020, he said the following, quote, "Let's make something very clear. There is no local law that makes it illegal to record the police. In fact, federal and state law allow people to record in a public space. However, we have seen officers inconsistently respond to recordings of their actions." Public Advocate Williams has attached a declaration emphasizing he understood and intended the Right to Record Act to supplant, basically to annihilate, the no recording policy of the NYPD. The committee report for the bill noted that the federal constitution protects the right to film police activities. The committee collected a number of federal cases that had recently affirmed that right. The council emphasized that as early as 2013, the United States Department of Justice had submitted a statement of interest in the case in the District of Maryland, writing that it is now settled law that the First Amendment protects individuals who photograph or otherwise record officers engaging in police activity in a public space. The city council also highlighted a Citizens Complaint Review Board report, which was released in 2017, that found that from January 2014 through December 2016, the review board closed 257 complaints covering 346 allegations in which civilians reported officers had interfered with their ability to record. So this is saying that that citizens review board that is supposed to be holding the police accountable, which clearly doesn't do that, they had actually closed 257 complaints out of the 346 allegations they received, which specifically included citizens reporting that officers interfered with their ability to record them. That same report was also cited by a former council member before he introduced the bill, when he stated that we must ensure every person is entitled to their right to record a police officer without fear of repercussions. That report detailed the scope of police interference with the lawful right to record and limited the remedies available to those whose rights are violated. But over the course of 2 years, the CCRB had substantiated 96 of the 257 allegations that officers had improperly interfered with recording. The 2017 CCRB report identified a policy shortcoming at the NYPD and recommended a change. At the time, the NYPD had issued a legal bulletin and broadcast a, quote, finest message reminding officers not to interfere with recording, but they had no patrol guide order directing officers how to protect that right. The CCRB, that's the Complaint Review Board, recommended that the department model its policy on an order issued in the District of Columbia's Metropolitan Police Department, which emphasizes that the members of the general public have a First Amendment right to record, photograph, and audio record police members while they are conducting official business in any public space. The city council voted to provide redress for those who had been thwarted, exercising a right that Mayor de Blasio described during his signing statement as about as basic as an American right as it gets, cementing your legal right to record with your camera interactions with police officers.
New York's Mayor de Blasio signing a series of police reform bills. Officers must display their name and badge number. The package also cementing a person's right to record the police, all in the interest of accountability.
I am signing this bill because I believe we can make it work.
So Mayor de Blasio, even useless as he is, even said, it is about as basic as a right you can get is recording the cops. The city council voted specifically to take away the police department's power to decide when, where, and how members of the public can record police. As then Chair Richards stated on the morning of the vote, we need you to say that the NYPD cannot decide how we're going to police this city. In any event, the bill's lead sponsor, then council member Jumaane D. Williams, specifically intended it to supersede the department's no recording policy. Williams said he was aware that the NYPD had issued a policy banning recordings in the precincts, which is the no recording policy, sometime in or before 2018. He said he was aware multiple courts had held civilians had a right to record the police. He said he was aware of the CCRB report showing the number of times NYPD officers interfered with recording of the police. And he intended the bill to protect the rights of those interacting with the police and of promoting social change overall. He specifically understood and intended that the bill would prohibit police officers from impeding recording in public spaces, including such spaces within police precincts. He understood and intended that the Right to Record Act would preempt and supersede the no recording policy, so that when the Right to Record Act passed, the right to record would exist and be enforceable inside police precincts. Williams, that's the sponsor of the bill, believed that the affirmative defenses provided to officers who were sued under the bill were sufficient to safeguard the concerns that the NYPD claimed required the imposition of no recording. Okay, so then they get into a legal analysis, but I do want to get into this declaration by Jumaane Williams himself. It's the declaration of NYC Public Advocate Jumaane D. Williams in opposition to the motion to dismiss. He says, I am the public advocate for the city of New York, serving in this position since March 2019. As public advocate, I'm one of 3 citywide elected officials with the sole mission of protecting and defending New York City constituents. As public advocate, I have a duty to protect the safety of New Yorkers. I act as an ombudsman for city government, providing oversight for city agencies such as the New York City Police Department, NYPD, investigating citizens' complaints, making proposals to address shortcomings or failures in city services. In the event of a vacancy or incapacity of the mayor, I am first in line to serve as the mayor. I am a non-voting member of the New York City Council with the right to introduce and co-sponsor legislation. I write to oppose the police's motion to dismiss. As explained in greater detail below, I believe this matter, the NYPD's unlawful prohibition of a citizen's right to record within the public spaces of a police precinct, raises urgent constitutional and public safety concerns, impedes transparency, fails to promote accountability of the government. These are matters of great concern. The proliferation of citizen recording of police work due to the ubiquity of cell phones and other mobile devices has changed the nature of policing in New York City. Citizen recordings have played a critical role in safeguarding New Yorkers and in holding police officers accountable for misconduct. While citizen recordings cannot solve the problem of police misconduct in public spaces, limiting such recordings makes citizens more vulnerable. Before my team drafted the Right to Record Act, I was aware that the Supreme Court had long held that the creation and dissemination of information is speech within the protection of the First Amendment. Prohibiting citizen recordings interferes with this constitutional right, the right to create speech and the end product of such speech itself. I was also aware that federal courts throughout the nation have specifically ruled that recording official police business is a constitutionally protected activity. Well before 2018, I became aware that NYPD officers were brazenly impeding this fundamental right by detaining, questioning,
Do you do the, what do you call it? Do the audit stuff?
threatening arrest,
Step outside, because then it's handcuffs afterwards, so step outside.
and in many cases, arresting and charging citizens, recording their interactions with officers.
That's it. Now you're going to jail. Put up your mask.
Or that of bystanders. These violations were well documented by the Citizens Complaint Review Board, an agency I cultivated a close relationship with as a council member and one I have preserved during my time as a public advocate. In addition to this general interference and in violation of the constitutionally protected right of citizens to record in all public spaces, the NYPD defiantly issued an internal manual that prohibited recording of police activity within the entirety of police stations, including areas open to the public. Unfortunately, the internal manual included misinterpreted law and ignored the salient body of law that permits civilian recording in public spaces. Moreover, the NYPD policy ignored the possibility of police misconduct occurring within police stations. It also ignored that police officers themselves are allowed to record within the precincts. In response, and in an attempt to end those proscriptive practices, the City Council codified the right to record in the Right to Record Act, which defended the right of citizens to record interactions with officers performing their official duties. The goal was deterring well-documented police misconduct in public spaces, including misconduct inside the public spaces of a police station. He says, I intended and expected that passing the Right to Record Act, that would supersede the no recording policy of the NYPD, and it would prohibit police officers from impeding recording in public spaces, including such spaces within police precincts. He says, I anticipated that this tool of ensuring police accountability would have a profound impact on civilians by fostering their belief that police work and practices would be fair since they would have eyes on the officers. I also want to underscore that the Right to Record Act, which I first introduced in 2016 and reintroduced in early 2018, and which was finally passed by the council in June 2020, had as a primary goal codifying the right of New Yorkers to record NYPD official activity in public spaces so as to protect the rights of our citizens and free them from fearing for their safety whenever and wherever they interacted with police. Such protections demand the right to record police activity within the public spaces of police stations. While citizen recordings cannot solve the problem of police misconduct, they do protect citizens who record their own legitimate and lawful conduct. The evidence demonstrates that recordings of police work have been central in documenting police misconduct. In fact, following the passage of the Right to Record Act, The increase in official findings of police misconduct, such as lying about official interactions with citizens, demonstrates the importance of civilian recording. And because police misconduct is not limited to the streets, it can occur in precincts. This check on government activity cannot be excluded from police stations. The recording of all police work in all public spaces is what we intended when the bill was passed. He says, I envisioned that a more robust protection of a citizen's right to record would address past concerns of police violence in our communities by shifting power differentials between police officers and the communities they police. Civilian recordings of police work can even out the playing field and can act as a tool to protect the rights of those interacting with the police and of promoting social change overall. While the police do surveil and record their interactions with citizens, as happened in this instant case with Patricia, too often, look at this, too often, the NYPD act as gatekeepers of police body cam recordings. Citizens cannot control when officers turn on and off their cameras. They cannot stop police from manipulating footage. They cannot stop the NYPD from delaying or refusing to make records public. With citizen recordings, citizens are free to publish their recordings for present and for future use. Thus, citizen recordings of police work have become a tool of police accountability and act as a check on government abuse. Despite or because of these facts, police officers continue to interfere with citizens' rights to record their official activities in all public spaces. I trusted and continue to believe that the affirmative defenses we placed into the bill struck a balance that would ensure the safety of officers while also ensuring the civil liberties of our fellow New Yorkers. Finally, I hoped that the possibility of dual recordings from citizens and officer body cams would start a rich and productive dialogue concerning law enforcement interactions. Unfortunately, the NYPD continues to act contrary to local law by prohibiting civilian recording within the public areas of precincts, as this case demonstrates. I do hope that in future, police adherence to the dictates of the Right to Record Act lead to a productive policing environment for officers and communities as was envisioned by the act and its sponsors. And then they also attach the administrative guide that the police say, look, this is a NYPD document, says individuals have the right to lawfully observe and record police activity, including but not limited to. And they give instructions to the NYPD, look, do not intentionally prevent or attempt to prevent an individual from recording police activities. Don't threaten, intimidate, or discourage an observer from record. Look, it says it. The right to lawfully observe, this is from 2021. When a member of the service encounters an individual observing, photographing, or recording police activity, this is an administrative guide by the police department. The right to observe and record police activity extends to individuals in public places, streets, sidewalks, parks, and private property where the individual has a legal right to be present, such as buildings, lobbies, workplaces, or an individual's own property. Look at this. They know. The police department knows. I could go on for another probably hour on this video, but I'm literally already been recording for an hour, 13 minutes. I really don't like these long videos like this, so I'm going to call it a day on this video. If y'all want me to make more videos about this, maybe like going through specifically the right to record law, maybe I'll send that over to Sean. Maybe he can make a video about it. Maybe we can lab on it or something like that. But I'm very conscious of the time. I don't like keeping people for that long. I'm going to try to keep this to under an hour, but who knows? I probably won't be, probably be over an hour. But yeah. So basically, long story short, TLDR, everybody agrees except for the NYPD that you're allowed to record inside police precincts. I hope that Patricia Rodney wins this case. I hope, honestly, Sean sues them and wins this case. I've reached out to Public Advocate Williams for comment because this does involve an ongoing case. I'm not sure that he will comment, but I will let y'all know if he does reach out to me. I do want to thank him for his work. I want to thank him for sponsoring the bill. I want to thank him for putting it out there and for defending our right to record the police, because it seems like nobody else is trying to defend that right. And that's all I really have for today. In the meantime, facts ain't defamation. Love you, mean it. Okay, bye.